It's a pleasure to be here and a pleasure to work with old and new friends. Summer has done a lot of the heavy lifting intellectually on the C128 case. She was leading the charge when I was scarcely aware of the case. So although I've been pretty active recently, I think it's accurate to describe myself as the tail to Summer's comet. Sebastian and I used to work together in the Jurassic era on climate change, and it's tremendous to see him again. Special thanks to Jacques, who has been incredibly generous in turning up at a presentation by a complete stranger, and I'm sure we'll really enjoy hearing something from a rock star in the state aid world. So thank you so much, Jacques, for coming along. I should start by saying that things have moved on a tiny bit since I wrote my paper. There's been a public consultation, which I kind of hinted at in the paper. And we now have some options, which I'll discuss in a bit of depth a little later on. We're going to divide the first presentation into 4 parts. I'm going to talk about the Aarhus Convention and its compliance committee, and then Summer's going to come in. We thought it would be better because she was involved in the case, and it's probably a good idea for her to talk about the case early on, and there's no one better to talk about the case than her. And then I'll talk about the implications of it and the options for responding to them. So the first part of the talk relates to the Convention on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters, the Aarhus Convention. And the title of the convention is so long, it takes up an entire slide. That's the only time I'm going to give it its full name. But whenever I do, I think maybe back in the 90s when we negotiated it, we could have come up with a bit more of a catchy title. In any event, that's what it's called. So what is it? It's an international treaty binding on virtually all European states, not just EU states, and the EU. It's got 3 pillars which flesh out the concepts of environmental democracy and international law. And the pillars relate to freedom of information, public participation, and access to justice, which of course is what we're going to be focusing on today. The EU's been a party since 2005. And the convention is part of a global family of instruments that relate to environmental democracy. It's a trailblazer, but it's not the only one. There was the principle, the Rio Declaration, Principle 10, back in 1992. And quite recently, there's been a regional convention for the Grulac region called the Esquazú Convention. The convention is quite unusual. Lots of multilateral environmental agreements have compliance committees, but very few have one like the Aarhus body, which was made by a decision under Article 15 of the convention. Broadly speaking, with a review of for the review of compliance by parties with their obligations. The committee comprises a group of internationally respected and fully independent legal experts. Well, internationally respected, except me, of course, but they're a body that is quite well known and recognised in jurisprudence in a number of jurisdictions. One of the things it does, perhaps the main thing that it does, is it considers what we call communications. The vocabulary in Aarhus is always a bit odd, but anyway, the committee gets communications which trigger cases. So people complain about a particular party failing to comply with the convention. And if the case is admissible, the findings, the committee will adopt findings, which when they're adopted by the Aarhus meeting of the parties, which is the main governing body, become official interpretation and legally binding on the parties. And in particular, we're going to look at Article 9.3 of the Convention, which requires parties to make sure that members of the public may enforce environmental law through judicial or administrative procedures. And the way the public does this is by challenging acts and omissions by public or private persons which contravene provisions of national law relating to the environment, which for our purposes includes EU law. And standing must be given to members of the public who meet the criteria provided for in national law. We'll look a little more about standing later on. It's quite a complex issue, but for the purposes of the introduction, I'll leave it there. And Article 9.3 is complemented by paragraph 4, which says that the remedies in Article 9.3 must be the procedures provided for in Article 9.3 must provide for adequate remedies, and they've got to be fair, equitable, timely, and not prohibitively expensive. So what the point of that is it's no good just having a free-floating and soft review mechanism. There have got to be consequences and remedies. And with that, I'll hand over to Summer, who's going to tell you all about case C128, which is at the heart of this.
So indeed, I want to discuss case C128 because I represented the communicants, that is the people who brought the communication to the Aarhus Convention Compliance Committee. I did so for Oberthür, which is the Austrian branch of the larger network of environmental NGOs called Justice and Environment. So essentially, I want to give you a brief overview of what I will be talking about today. Firstly, I would like to discuss what was the impetus for case C128, because it's important to have some of that background. And secondly, what led to the C128 findings and recommendations. So the impetus was the UK proposed construction of 2 nuclear reactors in Somerset, England, Hinkley Point C, or as I will refer to it as HPC. And this is an enormous project. And as you can imagine, it would be absolutely impossible to realize were it not for massive state aid. And we have a state aid expert who can elaborate. So I would just give you the basic definition stemming from Article 1071 TFEU. It's a subsidy or any other kind of aid provided by the government that distorts competition or the free market. So that's what it did. And an important aspect of the state aid process is that all state aid has to be notified to the Commission. The Commission has sole competence in state aid matters. So they have to be notified, then they have to determine if something is in fact state aid, and if so, unless the state aid falls under a specific exemption, it cannot be permitted. The Commission cannot authorize it. So it's essentially the presumption is state aid is illegal. So in the particular case of HPC, they had actually a few measures that they proposed, state aid measures. The primary one being the contract for difference. And this was used to increase investment security. Essentially, it was to guarantee sort of revenue streams at above market conditions. And if this was for the producers of the nuclear energy and it was designed to create investment security. So for example, another one of the measures was that should for political reasons, the UK decide, like Germany did, we want to get out of nuclear energy, then the energy producers in that case would be paid back for their loss and profits. But I do want to emphasize, I don't know what that microphone is. I do want to emphasize though, the state aid process and the Commission's role in controlling it can take all sorts of different forms and have different processes as part of it. And so this HPC example is really just one flavor, one kind. But you can imagine state aid for big coal projects, extraction, coal power plants, hydrogen power. You can imagine also schemes for supporting plantation of non-native trees in vast areas, in areas that are either next to or in protected areas, all of which it's impossible to imagine could not have the potential for enormous negative consequences. And by the same token, you can imagine an aid scheme for renewable energy that could be very beneficial indeed. So there could be positive aspects as well. So all of this was not lost on this. And this is why the word I used, impetus, is important, because yes, it triggered this thought process for us, Hinkley Point C, but in fact, we were very, very aware that this is a general, very, very systemic problem indeed. But to return to this impetus, this is the chronology essentially. In 2013, the UK notifies state aid for the HPC, and the Commission opens up a formal investigation under Article 108.1 TFEU. And in this opening decision, it expresses grave doubts and references, actually analyzes at detail, key provisions of EU environmental and energy laws. Then in 2014, in a real unexpected U-turn, the final position was a positive decision authorizing the aid under Article 108.2 TFEU to authorize the aid as compatible with the internal market using the exception under 107.3C. And just so you know what it is, it's essentially aid to facilitate the development of certain economic activities or certain economic areas where such aid does not adversely affect trading conditions to an extent contrary to the common interest. And we noted very, very much in the 2014 decision, there's little to no mention of the same EU environmental and energy laws that were so very, very deeply analyzed in the 2013 opening decision. So environmental NGO Global 2000, that's Friends of the Earth Austria, they oppose this decision, and they also fear its potential for setting a precedent. And I won't go into it, but I can assure you their concerns were very well placed indeed. So they go to us lawyers at Oberthür, and they say, well, what can we do? How can we challenge this? And well, my short answer was, we can't do anything. We are totally blocked. I will go into the reasons why we were blocked later, but in thinking about it, I realized I think we, however, have the elements to meet Article 9.3 of the Convention, and therefore, this lack of access to challenge these decision-making violates Article 9.3, and it follows that we therefore also have no adequate and effective remedy under Article 9.4. So off in 2015, we file our communication to the Aarhus Convention Compliance Committee. So moving to, okay, what led to the C-128 findings and recommendations? The case was obviously found to be preliminarily admissible. I recall at this point the elements that were touched upon by Alistair, namely, each party shall ensure that where they meet the criteria, if any, laid down in its national law, members of the public have access to challenge acts and omissions by private parties and public authorities which contravene provisions of its national law relating to the environment. And again, the lack of access means an Article 9.4 violation. So going through those elements just one by one, members of the public, well, this was a no-brainer. Oberthür and Global 2000, Friends of the Earth Austria are established NGOs. We qualify, that was never contested. Acts, this seems to me, there was some controversy at the hearing, but this is also basically a no-brainer. Article 18082 decision-making has legal effects. It confers the right for the member states to give the aid, and without that, the aid is illegal. So that is an act within the meaning of Article 9.3. Public authorities. Well, the EU challenged this as well, saying, well, the Commission is acting as an administrative review body, not a public authority as defined in Article 2.2 of the Convention. Article 2.2 lays out the definition for what is a public authority, but there are notably two exceptions, namely those who are acting in a legislative or judicial capacity. Here they said we're essentially acting in a judicial capacity, which we very much doubted. And in fact, here the role of C32, a case for which Alistair McGlone was the curator, a case brought by Client Earth, was helpful because by the time that our case was moving along, the Compliance Committee had already said administrative review bodies do not fit into this exception. They're not acting as judicial in a judicial capacity. And I would say that's especially clear in the case of the Commission doing state aid, where they're, if anything, acting more like a permitting body and not doing administrative review. So contravene provisions of national law relating to the environment. And I have to say, this is potentially the trickiest element that we had to face in our Article 9.3 analysis. So can state aid decisions meet this requirement? And we thought about it, and we communicants observed, and were also helped with very astute observations by the observers Client Earth that yes, absolutely, these state aid decisions have the potential based on to conflict, to contravene primary and secondary laws and instruments, including Articles 11 and 194. Just to recall, Article 11 TFEU says environmental protection requirements must be integrated into the definition and implementation of the union's policies and activities, in particular with a view to promoting sustainable development. Article 194 TFEU is the legal basis for energy, but note it also has with regard to the need to preserve and improve the environment in its chapeau. And if you look at all of the secondary legislation implemented on that legal basis, they're full of references to the environment. So this was our arguments. And we were confirmed very happily by the judgment from the Court of Justice of the EU in case C598/18, Austria v. Commission. Interestingly, this was actually Austria's challenge against the state aid decision for HPC. So in parallel to our process, there was this process going on before the Court of Justice. We just had no possibility to join in on this. Now, I'm not going to read the whole section. In fact, there's some other paragraphs as well from that opinion, but just wanted there for your future reference. What it's basically saying is when the Commission is reviewing a state aid, it must check that that activity does not infringe on EU environmental laws. And if it does infringe these laws, the Commission cannot authorize the aid. And what was so interesting in the discussion by the court is they named precisely the same actually they added more, but they added the same primary legal provisions that we had alleged were important for establishing the potential to contravene laws. So this included Articles 11 and 194 TFEU and secondary legislation. A key point not to forget is they said also this requirement to ensure compatibility with laws related to the environment holds regardless of whether or not the activity in question is pursuing a specific environmental purpose. This was our contention was this cannot possibly be true. And yet the Commission and the General Court in this Austrian case said, no, we disagree. We think only if it has an environmental purpose does a consideration of environmental matters become relevant. So if it has another purpose like pursuing nuclear energy, there is no need to consider these aspects, these environmental aspects. But the judgment by the Court of Justice of the EU disagreed with that, said, oh yes, indeed, it doesn't matter what the purpose actually is. Now, this judgment made the Compliance Committee's job really easy. So it said it considered it beyond argument that state aid decisions can potentially contravene European law relating to the environment within the meaning of Article 9.3 of the Convention. And I just want to emphasize, so I'm not misunderstood. I'm not saying that we would have failed on this element had it not been for this particular judgment. It's just that when I read that judgment, a very big smile went on my face because I knew that on this element we could not fail. I mean, it was just beyond reasonable doubt, beyond any doubt, really. So the last thing we had to prove was, to my mind, sort of the easiest. Did we have access to challenge? Now, the Commission did try at various points to challenge aspects. There are many different pathways that you could conceivably think of where members of the public, including NGOs like us, would have a way forward. Yet one of the first ones they hammered on, the Commission did, was the preliminary ruling procedure and why why didn't we use that? But the Compliance Committee in C32 had already looked at that in quite some detail and laid out the very, very many reasons why, no, this is not an adequate way of challenging these 102.1 TFEU decisions directly. And similar to that, access to justice at the member state level, there are various reasons why that's insufficient. I, again, won't go into all of them, but crucially, it doesn't go to the heart of the matter. It's not attacking the decision-making of an EU institution or body that is contravening laws relating to the environment. And we know that access to justice at the member state level is very, very spotty indeed. It's not sure you even get standing to do that. I'm not saying it's irrelevant, but it does not change the fact it is not a substitute for lack of direct access. No direct access under Article 2634 TFEU. This was also established in the earlier Client Earth case C32. I don't know if I should just move on in the interest of time, or if people are maybe familiar with the Plowman and Kofa's doctrine, and I can put that in my slides if needed to elaborate, or if people have questions. And I'm not seeing, yes, the internal review under Article 22A of the Aarhus regulation, which provides for an internal review process of Commission decisions, explicitly excludes state aid decisions from its scope. So that was no question, that was uncontestable. The committee also reviewed the complaints procedure under the state aid procedural regulation. And there they doubted whether that sort of ability to ask a party, ask the Commission to look into the matter was really sufficient. Is that the same as access to justice, an administrative or judicial review procedure? They didn't look in, as Alistair did somewhat more, whether even possibly we NGOs could qualify as an interested party and able to use that particular mechanism at all. And it's clear, obviously, intervention was not sufficient for an NGO to intervene in existing ongoing litigation, that it's relying on a third party. You can't control the procedure. And we also know cases where intervention was not allowed with the reasoning of the exclusion in the Aarhus regulation. So basically, no access. The Compliance Committee agreed with all of our arguments, and these are their findings and recommendations. And again, I'm not going to read the entirely long, precise words, but essentially the committee said that by failing to give access to members of the public to challenge Article 108 decision-making, the EU failed to comply with Articles 9.3 and 9.4 of the Convention. And the recommendation is fix it. And there are two ways to fix it, they suggested. Either amend the Aarhus regulation, take out surgically this exclusion for state aid for access to internal review, or come up with new legislation that will address the concerns. So that is what happened. That was case C128. And I then will turn it back to Alistair to say, what the implications are and how can we move on from there.
So when I wrote my paper, I was following the mandate the Commission gave itself to look at C128. And the mandate it's followed in its public consultations, which I'll tell you a bit about later on. But the Commission said that they were going to look at the implications of C128 and the options for responding to it. Now, I think I've got a bit of I've got a different story to tell about the implications. There's quite a lot of difficulty in this case because it involves different communities, which is why it's great to have Jacques here, and it would have been nice to have DG Comp here too. But I would argue that there's a need to zoom out here and not discuss this as merely an environmental or a state aid issue. And I argue in my paper that the C128 has important implications, and I can't list them all, but I'll talk about three of them here. And the first is, I think the EU really has to respond. The first implication is the EU must respond to the importance of environmental considerations and provide a means of enforcing the Austrian case by the public. Second thing I'd say is that it would be terrific if the Union could now repair the damage that its behaviour in the Aarhus mob has caused to its reputation as a champion of the rule of law. And I would hope the EU would be able to reinforce its position as a global leader. But moving swiftly on, let me talk about the first implication and the relationship between state aid and environmental protection. And the importance of environmental considerations in the state aid world is just burgeoning all the time. I mean, they're always quite important. But if you single out recent developments, it's all becoming quite paramount. There's the Green Deal. The ambition of the Green Deal requires state aid to provide a positive contribution and not to undermine environmental protection in the Union. Now, maybe I can just digress for a second here, because I think when I've talked about this before, I've given the impression, and I'm sure it's my fault, that this is all part of an anti-state aid agenda, that there's a group of environmental nutcases who think state aids are necessarily a bad thing. And this is far from the truth. I mean, state aids can be both a powerful tool to incentivize measures that protect the environment and address, for example, climate change. But of course, state aid also has the potential to support projects that undermine the long-term climate and environmental targets. And one would hope that the public could intervene on both sides, both to challenge decisions which wrongfully refuse to recognize environmental aids as conducive to the internal market, and the reverse. So the first thing I want to point out is the burgeoning importance of environmental considerations, because at the moment I'm particularly focused on climate change. I can't help but mention the sixth assessment cycle of the IPCC, which is really providing a dire warning now about the urgency of addressing climate mitigation. And of course, as we all know, there's the energy price inflation caused by the Ukraine war, which has led to pressure to increase exploitation of national hydrocarbons and runs a risk of sunk costs, stranded assets. So I'd move on from there to say, as Summers told us, I probably don't need to say much more about this, but the Austrian judgment, the Hinkley Point judgment, hardwired environmental considerations into state aids. I mean, the important points to note is that if a project breaches EU law on the environment, it cannot be declared compatible with the internal market. It's hardwired in, and similarly, the Commissioner are now under a duty to check that an activity doesn't infringe EU environmental rules. So we've got first a political and existential importance of environmental issues. We've got a clear ruling of the jurisprudence, but we lack of the CJEU, but we lack accountability in the courts. And I think this is an obvious deficit that needs to be made up. Second, I'll turn to the rule of law, and I've written about this at length, and I'll focus on the rule of law at the international level, because there isn't much time to do anything else. And what I'd start out by saying is, if the Union isn't going to champion the rule of law at the international level, who is? We need the Union there. We need the Union in a leading role, and that's a very obvious part of EU law. Just looking at Article 21 TEU, the Union's action on the international scene has got to be guided by respect for the Charter and the international law. And it's got to consolidate support for democracy, the rule of law, and principles of international law. And this is echoed by an early commitment, a personal commitment by President von der Leyen who said there can be no compromise when it comes to defending our core values. Threats to the rule of law challenge the legal, political and economic basis of how our union works. Which is great. That's exactly the sort of thing we need. We need the union to be saying. You've got to contrast this with what happened in Aarhus, and not just in C128, but in C32 as well, which is my case, but I can't really tell you much about it in the time available. But if you read the saga in my paper, you'll see that in both cases the union undermined the findings of an independent and impartial compliance committee, and it used its power. I mean, it had enormous power in a regional convention and used it to block consensus and to compromise and delay a legal process, resulting in findings on compliance. So it would be great in these dark times where we really need the rule of law for the union to recognize that perhaps it's setting a bad example, particularly if it wants to be a global leader. Again, we need the union to play this role. If not the union, who else? Who else is going to lead on climate change? And the union clearly perceives itself as having this role. The union is a global leader in the transition towards climate neutrality. And yet, in a multilateral environmental agreement with a forum, a meeting of the parties of an MEA, the union with civil society and other European states, including Belarus, who had problems of their own looking on, was obstructive. And there were howls of protest from civil society, from other states and so on. I mean, I've just quoted one statement in my slide. There could be many others, but YEE, Youth and Environment Europe, said international law is not to pick and choose, said the EU was being hypocritical and undermined its credibility in all fronts. And you know, as you need to invest faith in what I would describe perhaps rather controversially as a kind of soft and programmatic Paris Agreement, you need to flesh out, drive the law forward, and you won't do that if you undermine the rule of law in another treaty. So, options, this is the last part, options for responding to the C128 findings. And just to refresh your memory, in July 2021, as part of a political compromise on the Aarhus regulation, the Commission committed to carrying out an analysis of the implications of C128 and, if appropriate, two terrible words there, if appropriate, coming forward with measures to address this issue by the end of 2023. Now, the Commission has started a public consultation, which you can all find online, and we've got some options. And much to my horror, I see maintaining the status quo is one of them. Now, as I'm in the privacy of a confessional with a group of very close friends, I can say to you in total confidence that when I was writing my paper, lots of my friends said you shouldn't even be talking about doing nothing as a possible option. You know, you mustn't even think about that. But in any event, and I didn't, as you can see, because you've all read it, but I didn't mention the do nothing option, but the Commission has anyway which was always possible because its mandate clearly implied that it might not be appropriate to do anything to respond to the C128 findings. A series of six or seven questions invite the public to consider maintaining the status quo. I mean, it's as if the EU had space to frame its own policy options without taking into account legal obligations. And I think there are clear risks attached to doing nothing. And while doing nothing is on the table, maybe I can just bang the lectern a bit and say that if the union does nothing, it'll incur further reputational damage. The implications of doing nothing, of course, is that the union continues to block the endorsement of the C128 findings. It could hardly consent to their becoming legally binding and then decide to do nothing. So I think part of the package of doing nothing is blocking the findings, which could go on forever and would do severe damage to the convention and its compliance committee. It might even fatally wound it. So what are the other options? Option one, amend the Aarhus regulation. Great. Good option. It complies with the access to justice pillar. It was one of the alternatives expressly recommended in case C128. It benefits from the clarity of its contents, clarity being lacking in options 2 and 3, which I'll come to. And it really provides legal certainty and meets legitimate expectations of member states, stakeholders, and beneficiaries by applying clear and well-known rules of law. So that was the first option, the first of the numbered options that the Commission has proposed. Now, I'd like briefly to comment on options 2 or 3. If you're wondering what that is, that's a poke. Probably, maybe 2 or 3 of you are familiar with the expression pig in a poke. And if I had time to explain to you, I would. I'll perhaps tell you about it over coffee. But the idea of buying a pig in a poke is you buy something and you don't know what it is. And then you take the poke, which is a bag, home, and you open it and then you see what it is and wonder why you spent money on it. So I think there's a bit of that element to options 2 and 3. I mean, both options are vague and incomplete. And this is despite the Commission having maybe a year to work them up. Option 2 is a work in progress. The language is vague and the Commission stresses that all elements are subject to change. And option 3 is full of, it's got possibilities. It offers a review mechanism similar to the one under the Aarhus regulation. It's just not as concrete as option 1. So much to your relief, I'm coming to the last 3 of my slides. Option 2, the second numbered option proposed by the Commission, is amendment of the State Aid Best Practice Code. Those of you who aren't familiar with it might want to know that the Best Practice Code is simply a Commission communication providing guidance to member states on procedures. And the thing about the code is it's soft law. Not only, I mean, that's not me inferring its softness. It says on paragraph 8, this can't create rights or laws or so on. So it's always going to be optional, which I think in itself means it doesn't comply with C128. It can't, if it's optional, it can't provide remedies. Option 2 may specify that only types of state aid decisions could be reviewed. That's a possibility, not a certainty. which is not consistent with the C128 findings. And I think, anyway, that it could not be judicially reviewed. I mean, there's been hints that it might, but I really don't understand the hints. And in the absence of a route to the CJ, all you're dealing with is a kind of optional complaints mechanism. I'm speeding up here, so I hope I'm not garbling. So option 3 is amendment of the procedural regulation, which isn't soft law. I mean, it lays down detailed rules for the application of Article 108 of TFEU. And this option would introduce an internal review mechanism similar to the one under the Aarhus regulation. Now, this may be a crazy thing to say, but I'll say it anyway. If you want a form of internal review similar to the one used in the Aarhus regulation, hey, why not just use the Aarhus regulation one anyway? It's the thought I'll leave you with. Again, it's a bit vague. There'll be possibility of specifying types of decisions subject to review, like in option 2. I'm not clear about and I don't think the option itself is clear about whether there would be judicial review under Article 263, the TFEU. I mean, the option says it may. The public may seek judicial review of the administrative review reply under Article 263 of the TFEU, but that feels to me a bit nebulous. But it has got its positive sides. I mean, it might create legal rights to review and binding consequences. And if this ever materialized, if this option ever materialized, then I think we need to look at standing very carefully. Because the definition of interested parties really doesn't require, in my quite strong view, the level of standing that the Aarhus Convention does. So breathlessly coming to the end, I'll just conclude by saying there's been controversy about access to justice to challenge EU institutions and bodies for years. I mean, C32 started in 2007. It's been a long, hard road, and there are a whole range of options that we're looking at. I mean, we could have a simple, concrete, Aarhus compliant one. We could have a flat refusal to do anything at all, or we could have something in between. But I think it would be great if we could resolve this in a way that restores the union standing in quite an important multilateral environmental agreement in a way that the union deserves. I mean, the union's played a very positive and concrete role in all sorts of multilateral environmental agreements. So this is all a bit of a pity. Anyway, sorry to go on. Thanks for listening. Over to Jacques.
Thanks very much. Thank you, Alistair and Summer. And perhaps before we go there, I just express the appreciation for taking us through the case very clearly, I think, and then spelling out the options. Fascinating to see how the different cases and the different judicial bodies kind of interact and influence each other, and give some ammunition to the lawyers to then act in other fora. But that certainly was one side of the story, and I guess there might be a different side to the story, which I hope Jacques will bring to us. So Jacques Derenne, please, I assume we'll get now a more competition or perspective.
Yes, thank you, Sebastian.
Of the presentation, perhaps. Yeah.
Maybe you will probably not be surprised that I will bring some different views or nuanced views and from the other side of the spectrum. And I would like to make just 5 comments quickly. One on the global perspective and to put back the issues into perspective in perspective of the procedure and the legal framework. Then to remind you about the great deficit of judicial protection in state aid. Environment is a tiny part of that, but all sectors in state aid have the deficit that you are complaining about. It will not change. The third one is some comment on Article 9.3 of the Aarhus Convention, and I would like to remind you of a case of the Grand Chamber of the Court of Justice in 2015, which said that it had no direct effect. So you need national law. Comment on Hinkley Point quickly, the case and the consultation. So first, to put into perspective the situation, there is a complete deficit of third-party access in state aid. Let's talk about state aid decisions. And I talk about state aid decisions when the Commission is adopting a state aid decision. It does not adopt a decision on environment law or on X and Y. It doesn't care about it. You just have not to violate it, okay? It's a state aid decision, promote the competition with some objectives, promotion of environment, energy, employment, regional aid, etc. But the only purpose is competition, not environment. So it's not an environmental decision. That's the first perspective. The second one, so state aid is not environmental law. And state aid procedure was defined and set up and constrained by the member state. They protected themselves. They protected their violation, okay? The treaty was set up and Article 107, 108 never changed. In 55, 6 and 58, the member state decided to have something tailor-made to them, to be protected, privileged, not like normal law subject. And the illustration of that is the first implementing regulation of competition law for antitrust was enacted in 62, Article 1762. So it took 4 or 5 years for the member state to explain how to implement antitrust against cartelists and how to implement state aid law against member state. It took 40 years. Mm-hmm. We waited for regulation in 92, 99, amended in 2013 and 15. This illustrates the fact that the state law procedure that everybody is complaining against, rightly so, is tailor-made by the member state to protect themselves. And the Commission cannot do anything about that. They are doing rule by law and they are complying with the law, which has been set up by the member state. If you want to complain against something, it's not to attack the Commission, you should attack the member state. Maybe attack the member state, all the 27 member states before the human rights, Court of Human Rights. That has been done in some antitrust cases. They are the responsible for the situation. And the treaty will never change. I can bet you it will never change on that point. So there is a bit of a stuck situation. I do not want to discourage you, but I do not see any change by any iota of the impact of the Aarhus Convention on that point. So the case law of the Court of Justice progressed some access judicial protection for 40 years. It was codified in the regulation, but we still have, because of the rigidity of the Court of Justice, a very difficult situation to challenge decision of state aid of the Commission. And environmental organizations are complaining, but when you will know that the direct competitor of a beneficiary can even not challenge, so not to mention you, huh? So the system is worse than you can expect. Huh? So that means that I do not see any change coming from you, but maybe from competitors, maybe. So second point, let's pause about the admissibility. So how to, when you complain against a stated decision, you complain against it for different reasons. If you complain against it for environmental reasons, it's a difficult start because the purpose is not environmental, it's competition. That's an issue. Of course, in Hinkley Point, I will come back to that. In the Hinkley Point case, the Court of Justice said that, of course, the Commission cannot violate EU law when it takes stated law, when not only environmental law, everything. So in Hinkley Point, it's not a revolution, it's just open doors. It's obvious, nothing new about that. But it doesn't mean that it has to assess environmental law. No, it just has to assess competition law. Is the state aid useful and good to develop that technology, that innovation, that nuclear point to produce energy? Not to protect the environment, to produce energy. That's the purpose of the aid. The purpose of the aid was not to promote environment, it was to promote energy. Not to the extent of violation of environmental law, but of course it didn't violate environmental law. The Court of Justice said it did not violate. So, admissibility to challenge stated decision. You have two streams. Either you have a decision of the Commission, which is in phase one, to be brief, or phase two. Phase one is a decision, as you know, where the Commission said, I do not object to that notification, and I declare compatible the state aid without further investigation. When it's in phase one, nobody can complain. It's over, except member states. Of course, they are all privileged. They can complain against anything if they want. Politically, they don't. So if it's a phase one, you can only complain by adducing procedural rights, i.e., in phase one, the Commission did not open phase two. The only thing you can say is that I complain before the General Court because the Commission should have had doubts to open phase two. And me, as a trade association, or as an interested party, as a competitor, probably not NGO sometime, yes. As an interested party, I complain because I could have the right to submit observations and I have not that opportunity. So that's the only reason, not on the merits of the case, only for procedural reasons to develop merits. And the second part is in phase two, when the Commission has followed the whole procedure and examined all the situation and opened the formal investigation procedure, it takes a decision in phase two, negative or positive. And if it's negative or positive, then only the beneficiary or the member state can challenge. Because forget it, for the rest, interested parties, they had the right to submit observations, but they are not individually and directly concerned. I'll come back to that. Let's come back to phase one. Who is an interested party? That's quite difficult. It is still being pleaded before the court now. I mean, one of the two cases now on appeal before the court. And I will illustrate that with two cases which are pending now. The first is the Monte Paschi restructuring of the middle-aged bank in Italy. And bondholders were complaining because they've been affected by a stated decision which accepted that the bank could have aid to be resolved and they lost all the investment. Bondholders, they say, I'm affected and I would like to comment and have not been able to comment. They lost their case. First, they were admissible. And the Commission challenged the case, saying, no, they are not interested parties. It is now before the Court of Justice to say, are they interested parties? They are affected financially in the investment, but they are not affected like the beneficiary or like competitors of that, etc. It's quite indirect. But there is a link. They are not competitors, but there is a link, concrete link, impact by the state aid, not the objective, the state aid. The second, on the other spectrum examples, is the case of the French fishermen who complained against the installation of wind farms in Normandy, etc. They complained against it. And then they went to national court, they were all rejected, and they had the case and they lost. Environmental law was complied with according to the national judges, the French judges, but they still tried to then challenge the decision of the Commission, which was a stated decision, approving the state aid to NG, EDF, and Iberdrola and others to construct wind farms to produce energy. Nothing to do with environment, to produce energy. And so fishermen, they are not producing energy. They are fishing fish, okay? So they are not in competitors with NG. Or they allude to the fact that they are affected. But are they affected by the stated decision, or are they affected by the decision of the state to construct, which was supported by the Commission, but not necessary? So, in fact, there is a misunderstanding there. They lost the case, they were inadmissible in general court, and they are now before the Court of Justice. But there is a difference with the bondholders. The bondholders, they were affected in some way indirectly in the flow from the stated decision. But here the stated decision just allowed the state to grant money to construct. But the decision to construct, i.e. to affect environment probably, is on the part of the member state, not on the part of the Commission. The Commission has nothing to do with that. It's a stated decision. It's like in Clip-on, to produce energy. And of course, it did not violate it. It didn't violate environmental law in theory. It is okay. The decision itself did not violate environment. So to explain you the difficulty for an interested party to access to the general court, and it's not a matter of environment. In the bondholder case, it's finance law, nothing to do with environment. The guy is completely stuck. They cannot challenge. And it's the same in all stated cases. Nobody can challenge, in fact, except the beneficiary, except the member state notifying, and the other ones. And then in phase 2, when the case was completely exhausted, then it's even worse, because in that case, even a competitor, the one who seems to be affected directly, but he is not easily, directly, and individually concerned, which are the two conditions. He has to have a quality, the act should be challengeable, so that should be a definitive decision, etc. And then he should have a quality to act. Then he should be directly concerned, so no implementing measure from the state aid, it's possible sometimes. And individual concern, it should be assimilated to the beneficiary. Even, for instance, even in some cases like it was Deutsche Post, I think, who was challenging aid to Belgian Post, etc. So a direct competitor of a beneficiary is not admissible to challenge an aid to the competitor, because he can never show easily that he's the uniquely positioned and that he's the only one affected in the same manner. So to enlarge access in that condition to NGOs who are defending environment, which is not the purpose of stated decision, I don't see the point. It's another planet for me. So the Commission will be smiling to you, but nothing will change. I would like just to mention my front point, Article 9.3 of the Aarhus Convention, the Court of Justice said that that provision does not contain any unconditional and sufficiently precise obligation. There's no direct effect. You cannot raise that provision before the General Court or the Court of Justice in support of any challenge. You have to go to a national court to try to have a case, etc. But it's not a text of an international treaty which can be invoked before a court, not directly. Not the Court of Justice said that. I'm not sure if this has been well inserted in the whole assessment of the issue. And then, in key point, when the Court of Justice referred to environmental law, it was just to say the obvious that, of course, any decision of the Commission cannot violate EU law. The purpose of the stated decision is state aid competition, but of course, in passing, it cannot violate any part of EU law, including, of course, environmental law. And in that case, the Court of Justice said, well, it does not. And then the member states have a shared competence for energy, and some like nuclear, others do not like nuclear, and those who like nuclear, they can do it. And the Commission can assess the fact that nuclear is useful for the development of energy, etc., without having a specific purpose to environment, because it's not a stated decision for environment. And for the consultation, you've seen there is a call for evidence published by the Commission. They try to explain what they will do. They will take note of the notice, etc., etc. I see your disappointment, Alistair, but nothing will happen probably. They will try to find a way. I've seen some comments I've seen on internet which are published. I don't know, it's a bit strange, but there is a guy, a professor of law, I think, an engineer, architect at Leuven, who said that the Aarhus Convention led to an exponential escalation in the abuse of lawsuits by citizens. NIMBY and banana. So NIMBY, not in my background, they say, you abuse lawsuits, you seem to be abusing lawsuits by saying, not in my backyard, etc. You know the syndrome. And banana, I didn't know that, I don't know if you know that, it's built absolutely nothing anywhere near anyone. The extension of NIMBY. So it seems that some people are even excessively, I think, accusing the process of Aarhus Convention to abusing the law. My point is not to tell that, of course, but to say that you should not have, I do not want to discourage you too much, but what you should do is maybe not to try to implement international treaty which have a limit in the EU law system. You should influence member state to amend the system, not the Commission. The Commission cannot, or the Commission would like, but do not dare to propose it because it will be refused by the member state. Because in state aid law, member states are like cartelists, but they are protected. The cartelists, they go to prison, but not the member state. They violate the law. They are sometimes sanctioned. Well, thank you.
Thank you very much. I guess that could open a whole debate amongst the panel already, because obviously these are very different perspectives, one coming from international law, international environmental law, one very much from the EU side of things, as far as I could understand the argumentations. And one wonders how they come together, how they can come together. But I'm just looking, there is something here already also in the room, whether there are any questions. Otherwise, I will look what's there online. So Sharon Turner says, has two questions. To Jacques, that you say that environmental law is not part of state aid law. Can this really be correct given the environmental integration principle in Article 11 TFEU, requiring environmental protection to be integrated into the definition and implementation of union policies and activities? the Aarhus Convention is part of environmental protection regime, so its requirements must be considered part of state aid law, question mark, right? And a question for Alistair and Summer, what is the position of member states on C1 to 8 and how the EU should respond, which probably picks up on Jacques' last point. You need to convince the member states, but even if you haven't convinced the member states, I think there's nothing preventing the Commission from making a proposal on resolving this. So I think this could be fascinating. If there's no further, then I know that Jacques wants to leave on time, but I would then first call on Summer and Alistair perhaps to kind of respond to that. I'm really wondering also how your argumentation squares with the European Green Deal, which says, you know, it should be integrated in all policy areas, the environment, etc. So, but I'm just sharing.
I think Juliet has a question too.
Answer the previous ones and my questions after.
No, edit perhaps.
Right. No, that was more a bit of response from the argument that Jacques just raised. And I think you're really making the case that there's very poor access to justice in state aid matters in the EU, generally speaking. Whereas clearly some undertakings, some competitors sometimes manage to go to court indeed. And those have been struggling, but I don't think the fact that the case law is extremely restrictive and that even undertakings can't go to court to challenge a decision is an argument not to give the right to other members of the public and NGOs. And I think especially in this case, we speak a lot in all these debates where the Commission raises a lot the specificity of the state aid regime. I think in our case, we have the specificity of the Aarhus Convention, which is a particular international convention designed to give access to justice in environmental matters for NGOs and members of the public. And I think that's indeed a specific legal instrument that we don't have in other pieces of human law. There's no international convention on access to justice if procurement law is violated by state decision. But we have one for environmental law. And I think at the end of the day, the fact that Article 9.3 or other provisions of the Aarhus Convention might not have direct effect in EU law is not exempting the EU as a party to the international convention to comply with its obligations under that treaty. The EU is very keen to enforcing international conventions that don't have direct effect against the other parties. Look at the Brexit agreement, that, you know, when the UK might be violating this agreement, the EU is keen on enforcing it against the other parties, but is not keen on respecting its own international law obligations that it committed to. And I don't think the lack of direct effect of one provision is actually exempting the EU to respect its direct obligations under the convention. So in that respect, I don't think there's room here for the EU to just say the regime with the design of the regime of state aid law that we've built in the EU must be kept as is, even though we have a particular international convention interpreted with authority by the compliance committee in that case, that the EU needs to respect, or would be, again, in a very difficult situation also politically at the next meeting of the parties in 2025, where we are actually in a specific field of environmental protection with specific rights for specific groups that we might not have in other cases. And I think everybody would be also happy the case will change this, because here we're speaking about what the Commission can do, how we can change the laws. If the case will change, and if the Court of Justice tomorrow says, we have a wider access to justice for members of the public, for NGOs, in the context of environmental law violation to go to court, I think we'll be happy. That might as well comply with the findings. It's just something that is out of the control of the EU executive, because it's just a matter for the court to change its practice. So I don't really think the argument that nobody can go to court, first, is not really true. And second, is not really an excuse to not comply with higher authority in that respect.
And then Harry had the two-finger intervention, and then Jacques.
Just maybe compliment from a slightly different angle. I was wondering about the isolation of competition so strictly from environment, considering already what is happening in the guidelines in the state aid field, but also in terms of what is happening in competition law at large, where I think there is this discussion ongoing. Austria just enacted law where you actually have to take an antitrust field environment specifically into account. So I think there is a change perhaps ongoing there. So that is more kind of just a pointer and remark.
Progressively, yeah. But two different things. First, to Juliette, it's a problem of consistency and body of law. I do not see how the Aarhus Convention could be a justification to make a specific case only for environmental issues to change the case law of the Court of Justice. This should be done for all sectors. Is that my problem of what I wanted to say? If the case law of the Court of Justice is so restrictive, it should be changed. They refuse to change it, and they should give access to other third parties, but not only in environmental issues. And I don't think that legally the Aarhus Convention is a justification to make a specific case for that. I agree with you that indeed judicial protection would be better for all third parties, and that we can change the case law easily. The treaty allows to do everything we can. It's just the Court of Justice which should be completely rigid, manipulated by the member state. That's the issue. My feel is to be consistent. We cannot accept that a competitor will be inadmissible because of that rigid case law, and at the same time, before the Aarhus Convention, you would have an NGO who would be admissible for what reasons. That I have a problem on that. That's not consistent. If the Aarhus Convention could, as others, push the ball to that direction, yes, that's good. But it will be one of the arguments we have. The legal community is arguing against the case law for the last 40 years against the lack of admissibility for third parties. It's not new. We have not waited for environmental, which is new. 20 years ago, we were not there, or 25 years ago, but 40 years ago, it was already a problem for the legal community, for third parties. So it's another layer in addition. So, but I understand your point. Yes, legal obligation, but probably it was a mistake for the EU to have signed this one because they didn't surmise the extent of which that would be interpreted. But according to the treaty and the autonomy of EU law, the autonomy of EU law cannot be challenged by international law. And it's not only the only example. In international arbitration, we have the same situation. In the ECT treaty in energy, the same. The EU is denouncing its commitment sometime because it's at odds with competition law. Then competition law and environment, yes, and the Green Deal is, of course, environment is in the center of state aid, but that's the objectives of certain measures. The objective is to protect environment and promote environment. But the assessment of the state aid decision will always be, can I allow a state aid which is prohibited in principle? Let's not forget, state aid is prohibited. And the task of the Commission is to say, yes, I accept this exception to free market for a good reason, which is regional aid or environment. Not more than that. It's not the reverse. And the Green Deal, of course, the Commission has some objectives and they will try to tailor the rules of state aid, but the first rule of state aid is to check that the advantage by violating free competition law is acceptable because there is a good objective, which is environment. So that's the balance of the Green Deal, but it's still an assessment of competition.
Okay. It's 2 minutes past half. I don't know whether you need to leave or not.
I have a call at 4, so if I leave in 10 minutes, 5 minutes,
okay, good. Then I will just mention that there's also a question online to you, which I think is about your understanding of the HPC case in Clay Point. But first would give the the word to the two others. And that is about whether your assessment was that the HBC state aid case essentially was the decision of the Commission was that had not violated EU law in general, whereas I think your interpretation was it hadn't violated EU competition law and state aid law. So, but anyway, can come back to that and elaborate if we have time. Because first, perhaps to Alistair, there was the question what the position of the member states is on C128 and how the EU should respond. Perhaps you want to say something about that and also react to Jacques if you.
Well, at a very general level, I'll say that Jacques and I aren't on exactly the same page, but how great it is that he's come here to tell us the other side of things. So I really appreciate that. Sharon's asked us about the attitude of member states. The Commission statement in July 2021, in which they mandated themselves to come forward with the consultation exercise, immediately prompted 3 member states to express concern. And gosh, it was Luxembourg, Austria and Denmark. Denmark, was it? Luxembourg, Austria, and we think Denmark immediately said, this isn't, we're not comfortable with this. More generally, of course, the member states, I mean, we all know, don't we, that administrations, and this applies to the Commission, it applies to civil services, it applies to governments, they're not monoliths. But if we imagined that the member states were a monolith, one way they express their views on this is by agreeing to conclusion of the Aarhus Convention. I mean, the member states did that, and in so doing assumed international obligations, which I think are necessarily integrated into the treaty. Very briefly, why the environment? Why should we focus on the environment? It's been that way since 1992. I mean, there are all sorts of reasons for 1992 being the date of the Rio Declaration. And there are all sorts of reasons, which we haven't got time to go into, but many members of the global community thinks the environment is a special case. The warning online of the flood of litigation, I've experienced this quite a lot as an official, you know, ministers, I shouldn't say that, should I? But anyway, I will. Ministers and constituents writing in saying these NGOs are just going to litigate all the time. But when you look at the statistics, and the UK has reasonably liberal standing criteria, environmental litigation is actually quite a small part of that. And I think this vision of the environmental community as a sort of litigious giant, a bogeyman, doesn't really stand up to scrutiny because it hasn't really got the resources. I mean, the resources are limited and they can't sue endlessly. And just one final thing. I was longing, Jacques, to hear you tell us the name of the Article 9.3 case, because I can never pronounce it. It's the Brown Bear case, but I thought you were going to.
The case I mentioned?
Yeah.
Sorry, I've not referred
It's the Brown Bear?
it's
the
Dutch case.
It's the Dutch case.
It's not the Souche.
No, it's the Dutch Vereniging Milieu Defensie.
Yeah.
Ah, right.
Anything
Yeah,
really
it's
different.
that
So it's C40112.
Oh, I thought you were talking about the Brown Bear case,
No.
which
No.
is
No.
okay.
Yeah.
Okay.
It's nothing to do with. It was, of course, the environment. It was not a state aid case.
Yeah.
It was a pure dioxide and nitrogen dioxide case, etc.
Yes.
Sama, you would want to compliment?
Yes, just a few points. First off, I know that they found it was not sufficiently suffice to be directly applicable. This is one of the reasons, and this what therefore, we have standing problems before the Court of Justice. But this is one of the reasons why the Aarhus regulation exists and has been amended since then. And I would add to Alistair what Alistair said about the member states. What the member states did all agree to not only start the convention, but indeed championed it, because it was seen especially as a great new instrument for supporting environmental democracy, especially in the East, EPA countries, but also EU accession countries. And so they did that, but then they also agreed to the Aarhus regulation change to implement the findings in C32, and went into the last regular session of the meeting with parties and accepted the endorsement that they had actually done their homework, so to speak, and that case was closed. So I think that, yes, this is a special, more sort of specifically narrow case to state aid, but I think indeed there is a way possible, an open door that we can push on that. And I think I agree, state aid is its own unique system, but I think, as was also suggested, we have Article 11, the integration clause. We have the Court of Justice in the case Austria v. Commission saying that these things need to be checked. The environmental aspects need to be checked as part of the state aid analysis, specifically as to the first condition in Article 107.3c. They have to check to see if there's going to be any infringements of EU law. And so, I mean, if there are, it's out. And so that is directly into EU state aid law. Also, I mean, I think you mentioned the EEAG and the guidelines obviously refer to water and waste. That has to be taken into consideration by the Commission when it evaluates aid. There are the notice forms that are given to the Commission, which also have questions about how the member state is going to comply with environmental law. So it is growing, changing, as Alistair said, it's becoming something that is increasingly recognized and important. And I see no reason why this cannot be implemented. Just a couple of last remarks. I think you said, regarding the French fisherman case, and well, why didn't they attack the windmills? And I see no problem with also attacking the windmills sort of at the member state level, but that still does not allow the people to challenge the 108.1 decision itself, which is not something entirely separate to, but is essentially in legal language a but-for condition for the realization of these wind farms. They would not be allowed to happen without it. So it is inextricably linked. It's not something merely separate. And last point, I think, you were mentioning that if I was mistaken in putting words in your mouth, excuse me, you noted that in some of these cases, well, including in the Austria v. Commission case, well, they lost, they lost. They found the Commission did its duty to check, or, it was all sufficiently done. But that's not the standard for Article 9.3. The standard is possible contraventions of EU's law relating to the environment. And the committee has already said laws such as taxation, for example, and certain financial agreements can be also things that are laws that can contravene, or acts that can contravene laws relating to the environment. So I could go on and on, but I want to add to that. I really, really appreciate it. I've taken copious notes, and I look forward to reflecting further on all of your comments.
I cannot react on all details, of course, but my main point is that the state aid law is so rigid body that it should be amended from the interior and not from the exterior. That's what I mean. the issues of access to law and justice in state law should be done on the basis of state law arguments, not on the basis of a specific sector needs to have more say, justifiable, like environment, but there are tons of other sectors. All the sectors of the economy are linked to state aid. And the problem of state aid we have now is it is the last, like tax, is the last sector where the member states are trying to do what they want to manipulate their decisions. Sometimes with good faith, sometimes with bad faith. They are controlled by the Commission, by the state aid law, but for the time being, third parties have no say sufficient. And the change should come from state aid law argument, from competition law argument, process law argument, but not having an exception suddenly for one sector. Is that my point, my fear? But of course, the influence of the Aarhus Convention has the advantage to show the deficit and to explain the deficit. But an NGO in environment is not less to protect than a competitor of a beneficiary of state aid. Both should be promoted for the same reasons. Is that the point? And the international agreement should be changed, amended, improved, yes, by the member states. The member states should, the contracting parties should change it progressively to provide unconditional and precise obligation in it. Then it will change progressively. That's the main point. And I think the UN is a bit too soft law. And of course, some of the options we have with the Commission with the best practice code is a joke. I mean, it will not give you anything. Best practice law is even forgotten by the Commission. So it's just nothing. It's no longer implemented. So having seen that in one objection for you, it's a joke. So voilà. We have to reconcile both, and the member states should do their job to help the Commission to change the law, the stated law, and to convince the court to change it, because the court doesn't want. But if member states were defending sometime the third party, that would change completely. But they don't, because they see state aid as a good tool for government to be elected, not more, like tax. You know, it's that the main problem of state aid. It is totally poisoned by politics.
That is finally a nice word. Nice one would be if it wasn't that the case that I have the last word. So I think we need to draw a line that testifies to the interest in the discussion that you've taken, Jacques, also that you've stayed beyond your limits that you told me before. Yeah, that's very kind. I think we have raised the most important points in the debate as they appear, and it's important that we have the different viewpoints at the table, I think, to be able to exchange the views. Obviously, the Commission does not exclude that state aid law could change, right? And that the Aarhus regulation could change, given that the consultations are ongoing. So something is moving there. And I think you very much also raised the point of, I guess, where we could also have an argument whether environment is just one of the other policy fields that might influence this, or whether it's actually a particular policy field that is highlighted in the European Green Deal, which is acknowledged there, etc. But we could, I guess, we could go on in the debate of what that means and etc. and the dangers and the possibilities that come with that for a long time, and I'm hope that we'll actually be able to continue that discussion at some point, but it will not be today, I'm afraid. So join me.
He's invited to. He wrote, and he was invited in the state aid dossier in the rigid legal committee of state aid lawyers. So he will have a say and he will be read with interest by the other side on that point. So it's a specific dossier of Revue Concurrence which I'm organizing on the access to justice, in fact, interested parties. I mean, how third parties can be any defended.
So you're all very much invited to have a look at the report, which is on the website, on the GovTran website, if you want, govtran.eu. It's accessible there to read it. And obviously the debate will continue after the consultations close in a couple of weeks or a week or something like that, I think. And then we'll see what way the Commission proposes to go forward, or perhaps not, as Alistair explained. That's for us to see still. Perhaps you can join me in thanking the panelists and the presenters, and thanks very much for a very informed and interesting debate, and looking forward to continuing that debate and seeing the new developments. Thanks very much.